Good morning, ladies and gentlemen. I would like to also welcome you to the GUE NGL press conference. The reason for this press conference is that we would like to present a legal opinion to you today, which has been written by an author who has sat next to me, to also provide you with the opportunity to ask questions on the content of the opinion. We contacted Professor Dr. Fischer-Lescano and asked him to clarify an issue for us from a legal point of view. He is a man with a great deal of experience when it comes to European law. And we last asked him to look at the extent to which the Fiscal Compact violates European law. And the reason we asked was that because we had the impression that when it came to important decisions which affect the member states and also us at European level, there being a situation where the rights of the European Parliament are being consistently violated and we are being denied the opportunity to play a role in important decision-making processes. So to be clear, we have a contribution to make to a debate which is taking place at national level, and we want to see this debate taking place at European level, which isn't happening at the moment. We want to be clear as a group here and send a signal that we want to strengthen the position of the European Parliament what we are experiencing at the moment is clearly a violation of the principles which we work by, that the European Parliament is being discriminated against, and we need to do something to stop this. So this is why we appealed to Professor Dr. Fischer-Lescano. We asked him to write this opinion, and he is going to present the opinion to you today. I'd like to start by clarifying the situation when it comes to European law. Broadly speaking, quite often criticism of European law has been expressed as a criticism of national law. Certainly speaking for the German perspective, these arguments have been tied up for now, but the broader question relating to European legislation, it's clear this can't be answered by national legislation. What we're talking about here are European principles, democracy, social rights, and we can't find the answers to these issues at national level, but we have to defend them at European level. So that's the background to this legal opinion, which follows on from the criticisms which have been expressed by President Schulz when it comes to regulating the European crisis, that the European Parliament was left sitting on the children's table, that they didn't have a proper role to play, and that they were systematically being excluded from the debate. So we've got a fiscal treaty which isn't a European treaty. The United Kingdom and Czech Republic have not signed up to this treaty. And what we've got now is a really mixed treaty where citizens should have been allowed to take part in the process of establishing the treaty, but we've got a situation where certain member states have followed different courses to others, and that's why we've got a real problem here when it comes to the participation of the European Parliament. We have seen the role of the European Union changing here. You've got certain member states putting together a treaty, and they are then lending out certain responsibilities to institutions, and they take over responsibility for certain measures, implement certain measures, certain powers. As you can see in Article 8 of the Fiscal Treaty, we've got decision-making possibilities, and then this transfer from a legal point of view is very problematic. Need to differentiate when it comes to resolving problems relating to European law and the approach which you take. First of all, the formal approach, the way in which the treaty was established. Now, this is problematic because the subject, the EU, was not involved enough in the process of drafting the treaty. So we've got this treaty which has been written, but it was written without the involvement of the European Union. So the decision-making institutions were not integrated into the process of writing the treaty. Now, what are the rules? According to European law, there are two possibilities whereby responsibilities can hand over to the EU. First of all, in line of Article 148, that the European Parliament should be incorporated, so a change in primary law. The European Parliament should have been involved. This wasn't the case. And up until now, and this is without precedence, the other path was taken. Now there's another example which is taken as an example. For example, the Schengen Treaty, that was also a treaty which came to be part of European law later on. But there you've got a situation where two different kinds of treaties are existing alongside one another and then integrated into European law, and that's where we've got these problems coming from. So here you've got a regulation which has been put together by certain individual member states, but then the EU institutions are used to guarantee that the correct procedure is used. Because according to Article 48, this procedure wasn't taken. The question is what rules do exist for this process? And in Article 216 of the TFEU, you can find the answer. It's stated there that the European Parliament is to be consulted when it comes to legislative changes such as this. This is referred to directly in the TFEU in Article 216. Now, you could say that this is a treaty which affects the member states. It's not European legislation, but the European Court of Justice has been clear on this when you're talking about taking on responsibilities in the implementation of the fiscal treaty. And from a legal point of view, the European Parliament must be included in the decision-making process. So this didn't happen. the Parliament wasn't incorporated in line with Article 48 or Article 216, that has led to the violation of European law. The Fiscal Pact is not in line with European law. Now, this doesn't mean that the treaty is void, but it means that the European institutions cannot play a role in the implementation of the treaty. And this is according to the democratic rules of the European Union. In Article 2, the Fiscal Treaty says that if there is a contradiction with European law, which is the case in the Fiscal Pact, you've got coalition standards which define what should happen. But the question is whether the EU is properly covered by the treaty. So you've got a real violation here as a result of the failure to adhere to a democratic procedure as foreseen by Article 206 of the TFEU. So from a material point of view, looking at the content of the Fiscal Treaty, there are 4 aspects here. Firstly, the Parliament wasn't involved in the drafting of the treaty, but also in the implementation of the Fiscal Treaty. Its rights were violated. The Fiscal Treaty envisages a role for the European Parliament which have not been respected. So when it comes to participation, so the requirements haven't been met by 2, and this is also a problem when it comes to secondary legislation. We're also seeing parliamentary rights being undermined.
And legally this is a problem. The reverse majority procedure is an issue here. This applies to some aspects of the six-pack agreement. At an EU level, the reverse majority is a serious problem because majority requirements are being turned around. You could take the view that therefore financial and fiscal primacy is being established because it's not a case of obtaining a qualified majority for something but against something, and that is difficult because the basic rules of interaction under primary law applicable to the EU institutions are being overturned in an international treaty, and other goals such as social policy goals and human rights are being subjugated to this fiscal policy goal in the form of austerity policy on a structural basis, and this primacy of fiscal and financial law is a legal problem. Fair cooperation between the institutions is impacted by this, and so is the question of protecting EU primary law. Thirdly, there's a substantive problem in the fact that the implementation of the debt break and the penalties attached will conflict with subsidiarity principles if applied by the EU institutions. They don't have a primary law competence to do that, and this would then impact on the 4th point, which is the structural reform programmes, which is Articles 5 and 6 of the Fiscal Compact. So, as a summary, in formal and material terms, there are problems with a view to the Fiscal Compact. It is therefore not easy to state what legal strategies could be adopted. the fact that we have problems with respect to Parliament's prerogatives pursuant to Article 216 of the TFEU is a case in point as set out in the report. I think bringing an action before the ECJ to establish a clarification of the legal institutional aspects of involving the EU is necessary. There are some material conflicts of law, and because of Article 2 and the Fiscal Compact, which deals with a conflict of laws, there could be significant legal uncertainties because it's not quite clear whether EU law should be applicable or the Fiscal Compact when it comes to implementation, and therefore to obtain a legal report on these issues would eliminate that legal uncertainty. And also, secondly, we would need to have such a procedure to deal with the fact that Parliament is being circumvented by the provisions of the legal compact.
Vielen Dank, Professor Dr. Fischer-Lescano.
Thank you, Professor Fischer-Lescano. Thank you for producing the report. As a matter of course, we will be passing it on to all MEPs in the next few hours, to the President, and I'll give a personal explanation to him and the leaders of the political groups likewise, because it's our belief that if it's possible to use this report to conduct a debate in the European Parliament and beyond, we should do that. It shouldn't be reduced to the Parliament, in fact. It should go beyond that, and it should deal with how, in the future, the democratic rights of the European Parliament and democratic rights at an EU level categorically can be strengthened. As far as what Professor Fischer-Lescano has advised us, we as a group will first of all go for the report option. In other words, we wish to talk with members of the European Parliament to establish how far they would support such a move.
Nicht als Fraktion, sondern in dem Fall muss es das Parlament.
In this instance, it would require a majority decision by Parliament to take action before the European Court of Justice to obtain their legal opinion in that form and to see what conditions could be obtained to have an EU-level debate of the Fiscal Compact. And we want to open the floor here to ensure that there is a political debate on the Fiscal Compact. We think that that is a necessity as MEPs, and we haven't had that yet. We've not had the opportunity to debate it, neither in terms of its impact on member states nor in terms of its impact on the EU per se. We haven't been involved at all when the question of loaning bodies of one sovereign construct to the other are concerned. So when it comes to the implementation of the treaty, we haven't been involved. The Commission, after all, is to be made responsible for implementation. Now, clearly we don't want to slam the door shut on bringing a complaint before the ECJ, but first and foremost, our main concern is to obtain assistance by bringing a question, a request for clarification before the ECJ in respect of this treaty or compact, because it seems that implementation by the European Union of the Fiscal Compact, having EU bodies implement it, is of decisive relevance. even if the treaty came into force on the 1st of January 2013, its implementation would be questionable. So that's the level at which we wish to conduct the debate. And we want, as soon as possible, to obtain broad support in Parliament to have such a debate in the plenary and to obtain a decision to that effect. That covers it from my side.
Merci beaucoup. Le texte de l'analyse.
Thank you. The text of the analysis is available in 3 languages, English, French and German, at the door to this room. I'm being told we have a few moments left for your questions.
Go
ahead, please.
Gaspar Sabag with Europolitics. To get broad support, to get a majority in Parliament is going to be quite a tough manoeuvre. I imagine the EPP and the S&D group will potentially fear upsetting the markets if you ask for an opinion that will potentially say that this is in breach of EU law. How will you convince them? What do you think their reaction will be? And also, you said the door wasn't closed to bringing in an action for annulment. What are the requirements for that? Is that also just majority? Thanks.
Zunächst erst einmal, warum haben wir...
Firstly, as to why we decided to go for this opinion procedure, the specific reason is that we take the view that it's more likely that we'd get a majority between MEPs. We know that there's been discussions in disparate committees about the non-involvement of Parliament. Parliament is increasingly being cut out of the loop, and that's resulting in swelling disenchantment in members of many groups, and we see this as an opportunity, therefore, to win round a majority of members to support such a procedure, and therefore to support a motion to this effect in the plenary, and a simple majority would be necessary in plenary to achieve that end. This procedure particularly with a view to the reverse qualified majority, is something which has been criticised on a number of occasions in Parliament, and this has played a part in the six-pack and the economic governance cases, and also the Fiscal Compact, and of course it plays a role again in the case of banking union. And we think on individual issues we are seeing issues that aren't dealt with in primary law being turned on their head, and important acts are being committed that we didn't want. And a number of members of the European Parliament outside our group are being irritated by that, and they see that their rights and prerogatives as MEPs are being infringed categorically, and we see that as one way forward.
Ich möchte nur ganz gern kurz präzisieren.
Let me just be clear about this.
Gutachtenverfahren betrifft das.
As far as this request for an opinion is concerned, it's not an infringement proceeding with regard to the treaty. It's intended to achieve objective clarity. So I think in your question it was implicit that there was some concern about that with regard to the legal and material certainty. We're asking the ECJ whether they see any possible problems with regard to the Fiscal Compact, and whether that can be responded to in the way the Fiscal Compact is drawn up to eliminate those difficulties. So this is an objective clarification procedure, this referral for an opinion. And there are other issues such as an action for annulment, which would be an opportunity which could be used to take action against an EU institution. You can't lodge an annulment action against the treaty itself. it would have to be against an institution. On the 1st of June, the Commission issued some information on actions to be taken in the case of failures to abide by the provisions of the Compact, and there was a period in which that could have been challenged in the form of an action for annulment, but that deadline has passed, so I think we need to look beyond that. Now, it may not be Parliament itself that would be the body raising an action for an annulment. It would have to be other bodies, probably. There are other ways forward, such as an action saying that subsidiarity hadn't been respected. Here, we feel that the method we have chosen, referring it for an opinion under Article 218 of the TFEU, is the most objective way forward for clarification. We've still got a few minutes for questions.
David Price. I write a column on Eurodemocracy and Schumann.info. Have you asked, I have, to get the opinion of the Council, the legal opinion of the Council on the background of this? I got refusal on 2 occasions. And Turco and a number of other judgments say that legal opinions should be available for the public to get some background on this. Secondarily, the treaties have a number of clauses, in fact a whole lot of clauses, which say the ECJ can be appealed to, but it's not entirely clear that if 3 people or 20 people or 25 people write a treaty and say we can appeal to the ECJ about resolving this, whether this is actually admissible by the ECJ. Just because you write a clause saying the ECJ is the Court of Appeal doesn't mean the ECJ will accept it. Have you analysed that aspect?
Vielen Dank für die Frage. Also, es gibt
Thank you for your question. So there are different approaches which the ECJ can take when it comes to admissibility. You've got the fiscal treaty itself. When it comes to the responsibility of the ECJ, when it comes to monitoring procedure, where the ECJ has a role to play. Now, that this is problematic, it refers back to a clause in European primary law that the ECJ is seen as an institution which can overcome conflict between the member states, but in my opinion that doesn't cover monitoring a procedure which has been led by the Commission, which we've got here relating to the Compact Treaty. It goes much beyond that. Now, when it comes to the request for opinion, that relates to European primacy law itself. Article 218 envisages this when it comes to international treaties. The ECJ can be appealed to by, amongst others, the European Parliament. And you've got 20 or 30 examples where the European Parliament asked or requested the opinion of the ECJ. So we do have examples when it comes to the ILO Convention, for example, amongst others, where the European Parliament requested the opinion of the ECJ. So Article 218, there are certain problems there that the ECJ can have, that you can request an opinion when it comes to instances related to the European Union. And here we're talking about the member states. We've got a treaty of the member states which we would like to request an opinion of. And then secondly, if you look at Article 218, then the definition is really very broad.
Subjekt EU-Völkerrecht.
When it comes to agreement and the binding nature of international law, and that's what we're talking about here, the binding nature of international law when it comes to several institutions of the EU taking on responsibility for the implementation of parts of the fiscal treaty. So if we've got this model, which will be applied in the future when primary law is being ignored and circumnavigated, when we're talking about future issues when it comes to stabilisation of currencies, the European Union's not going to be able to contradict the member states here, and we can't allow this situation to emerge that the member states are simply ignoring the European Parliament and other institutions of the EU and taking decisions without adhering to democratic principles.